What's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota, yada, yada, yada. If you're in Minnesota, call me. You know, we'll talk law, fix all your problems, grab a whiskey, whatever we need to do. Look, guys, it has been a minute for Alex Jones. It's actually been a lot of minutes. Alex Jones has a lot of cases going on right now, but this is one that we visited a while back, and finally there's been some real progress on the case. This is the case of Matt Furie, the creator of Pepe the Frog, versus Alex Jones through his two organizations, Infowars LLC and Free Speech Systems LLC, for the act of copyright infringement, the claim of copyright infringement against Pepe the Frog. So the first video happened a long time ago, and an answer was expected a very long time ago, 21 days after that long time ago. But as things typically are more complicated, there was a bunch of procedure that happened between the actual summons and complaint and the answer being served. And in that time, there were motions for all sorts of things. There are motions to mainly for continuance and extra time. And then actually there were some objections to some of the statements in the original complaint. Matt Furie filed a amended complaint, and then he actually filed a second amended complaint just on like July 5th or something like that. It was very, very recent. And that was based on an agreement that some of the statements in the first amended complaint would be taken out, and they would file that second amended complaint, and then Infowars and Free Speech Systems had agreed to respond after that. So all of that is a lot of boring procedure. I'm not going to go through it. Really, not in this video, for sure, because this video will be long enough. Though hopefully not too bad. And it just gets us to where we are now. And this is the important part. Once you've gotten past some of the initial motions and stuff like that that occasionally happen, you get to an answer. The answer document is the defending party's first chance to tell their side of the story to the court, but they have to lens it through the complaint. And there's a lot of strategy at play, and you'll see some of that in this document, and I'll talk about it as we go. But, I'm not going to dally too long on this intro. It's long enough. I'm going to just delay long enough to get a little bit of this. Oh, come on. Sorry, a little bit of this Basil Hayden's Kentucky bourbon, and then we're gonna jump in and see what's what. So, fair warning, this document is 17 pages. I considered comparing it side by side to the amended complaint as a way to go through that, but I don't think it's really necessary to do so. And answers to complaints, as you'll see, are pretty is like, I deny everything. That's how it goes. And so when I say this is 17 pages, a lot of it's going to move very quickly because there's a lot of denial and a lot of repeated phrases. But then it gets to, affirmative defenses and stuff, and we'll talk about that when we get there. And some of them may sound a little familiar if you watch the other video. Okay. So this, importantly, this is Infowars LLC's answers and affirmative defenses and defenses. This is not Free Speech Systems LLC's answer, defenses, and affirmative defenses. That will be a separate document that I will cover separate, in a different video. Actually, it may be out. I might have just missed it, not even thinking that there would be two complaints. But I'll check. But if that one's out, they still have a little time. But if that one's out, watch for that video as well. it'll be concurrent with this one, and it'll probably be pretty similar, but some of the stuff will be different. So anyway, and in that video, I'll talk about only the differences, and it will save some time. All right. So, final preface. I'm going to go through this, but where there are sections of a lot of repeating of just denials and the same phrases over and over, we're going to move through those very quickly, and I'm just going to kind of breeze past them. Let's get just to the meat of the document. This type of document, it's not important to read every single word. So Infowars LLC, by and through undersigned counsel, hereby responds to the Second Amended Complaint filed by Matt Furie. Infowars answers and avers as follows with numbered paragraphs corresponding to like-numbered paragraphs of the Second Amended Complaint. Infowars denies each and every allegation of the Second Amended Complaint unless specifically admitted herein. So just in case every single one doesn't have a denial in it, which it pretty much does, they're stating at the onset that they disagree with everything that's in that complaint except for what they specifically agree to in this one, just to kind of try and eliminate some ambiguity. So, nature of the action. Infowars admits that the Second Amended Complaint purports to state a cause of action for copyright infringement. They deny all other allegations in paragraph 1. And this is a phrase you're going to see a lot. Infowars lacks knowledge or information sufficient to form a belief about the truth of the allegations of paragraph 2 and therefore denies them. So if Infowars, if Matt Furie has alleged some sort of fact and Infowars shouldn't have any real knowledge of that fact, or, has no way to have that knowledge. So, for example, Matt Furie says he created Pepe back in whatever year. Infowars has no idea when Matt Furie created Pepe, or technically, they have no idea if Matt Furie created Pepe, so they're going to deny that. And Matt Furie may be able to prove that he created Pepe, but that's fine, but that's not Infowars' job to admit to that. For all anyone knows, Matt Furie's best friend actually created Pepe and said, you know what, you can use this, and Matt Furie was just the first guy to publish it. I'm not saying that happened. Neither is Alex Jones or Infowars or Free Speech Systems, okay? That's not what's going. But I'm just saying there's no way for Infowars to know whether or not Pepe was technically created by Matt Furie. They don't know if he got the idea, if it's derivative of something else, all sorts of different stuff could happen. So that's why they're going to deny anything that they cannot specifically admit to, because it's Matt Furie's job to prove these things, not theirs. Okay, Infowars admits, this is paragraph 3, that a character commonly referred to as Pepe the Frog featured prominently in internet memes by 2014. Except as expressly admitted, Infowars lacks knowledge or information sufficient to form a belief about the truth of the remaining allegations of paragraph 3 and denies them. Doesn't know the information for 4 and denies. Doesn't know the information to 5 and lacks knowledge or information sufficient to form a belief about the truth of the allegation regarding the others in paragraph 5 and therefore denies them. Number 6, here we go. Infowars admits that the allegedly infringing poster, features images of U.S. President Donald Trump, social and political commentator Ann Coulter, political commentator and public speaker Milo Yiannopoulos, political commentator and radio show host Alex Jones, political commentators and social media personalities Lynette Hardway and Rochelle Richardson, popularly known as Diamond and Silk, political commentator and YouTube personality Paul Joseph Watson, counselor to the president, President Trump's campaign manager, and political consultant and commentator Kellyanne Conway, campaign advisor, political consultant, lobbyist, and strategist Roger Stone, political commentator and creator of the Drudge Report, Matt Drudge, a likeness of Pepe the Frog, and patriotic imagery including the flag of the United States and the United States Capitol. Infowars admits that the poster includes the text MAGA. Infowars admits that MAGA is short for the Trump campaign slogan, Make America Great Again. Infowars denies that it sold the poster. Except as expressly admitted, Infowars denies the remaining allegations of paragraph 6. So Infowars says that they did not sell the poster. What that likely means is that Free Speech Systems LLC sold the poster. But I don't know. I haven't read their answer yet, so we'll see. So Infowars denies paragraph 7. And Infowars admits that the Second Amended Complaint purports to state a cause of action for copyright infringement. It denies all other allegations in paragraph 8. All right, so that's the intro. Jurisdiction and venue. Infowars admits that this case purports to be an action under the Copyright Act of 1976, Title 17 U.S.C. 101. Infowars denies all other allegations contained in paragraph 9. And yeah, it's important for Infowars not to just admit all of the jurisdiction and venue issues. Make them prove it. Make them prove it. And you certainly don't want to admit that they have a cause of action. They purport to have a cause of action. They have to prove that their action is actually valid. So 10, Infowars admits that this court has subject matter jurisdiction pursuant to 28 U.S.C. 1331 and 1338A. Infowars denies the allegations of paragraph 11. Infowars admits it is a Texas limited liability company managed by Alex Jones. Infowars denies that it operates an organization that includes nationwide radio programming and the website Infowars.com. Infowars lacks knowledge or information sufficient to form a belief about the truth of the remaining allegations contained in paragraph 12 and therefore denies them. Infowars denies that it regularly conducts and solicits business in California and this district. Infowars denies that it sells products online, by mail, and by telephone to residents of California and this district and ships those products to buyers in the state. Infowars lacks knowledge or information sufficient to form belief about the remaining allegations of 13. 14. Infowars admits that the Second Amended Complaint purports to attach a list of radio stations that run the Alex Jones Show as an exhibit. Infowars denies the remaining allegations of paragraph 14. 15. Infowars denies it has an online store. And if you check out InfowarsStore.com, which makes you think that Infowars has a store, it's actually owned by Free Speech Systems, LLC. So that's an important distinction here because there are two separate entities that are both defendants in this action, and each one will defend itself separate from the other. They will each potentially have different defenses available for the same actions. Like in this case, it's pretty hard to say that Infowars violated anything if they didn't sell the poster, right? If Infowars had nothing to do with the sale of that poster, then Infowars isn't a proper party to the action. It should be dismissed as to them. So they're probably going to try to do something like that, but we'll see. Infowars denies that it has committed acts of direct infringement in California and this district in violation of plaintiffs' intellectual property rights, lacks knowledge or information about the remaining allegations in 15. They flat out deny 16 through 20. So those are done. Parties. They lack information on 21. Infowars admits it is a limited liability company organized and existing under the laws of Texas with a registered address at 100 Congress Avenue, Austin, Texas. Denies all other allegations of 22. They lack knowledge in 23. They flat out deny 24. Now, as you'll see here, 25 through 35, they lack knowledge and therefore deny. These are all about the origin of Pepe. 36. Infowars admits the Second Amended Complaint purports to attach copies of copyright registrations and applications and exhibits. They deny the remaining allegations of 36. They lack information and deny 37 through 48. On to 49. Infowars admits it was founded in 2007 and is managed by Alex Jones. Infowars lacks knowledge or information sufficient to form a belief about the truth of the remaining allegations of 49. They lack information on 50. 51. Infowars denies that it owns the Infowars.com website or an online store. Infowars lacks information for the rest of 51. 52. Infowars denies that it owns the InfowarsStore.com website or an online store. Lacks knowledge for the rest. Same thing for 53. 54. Infowars denies that it has radio programming or products that are heavily advertised on its alleged radio programming. Infowars lacks knowledge or information for the rest of 54. 55 is a repeat of that information about the poster, who's on it, and what they're admitting to. 56. Infowars admits that plaintiff filed his original complaint on March 5th, and they lack the rest. 57. Infowars admits that the Second Amended... Guys, I can't say amended anymore. I can't say it. The Second Amended Complaint purports to show that more than one reviewer noted Pepe's presence in the poster. They deny the rest. 58, 59, and 60, they lack information and deny. Count 1, copyright infringement. Infowars repeats and restates its answers to paragraphs 1 through 60. They admit the Second Amended Complaint purports to attach copies of copyright registrations and exhibits, and they deny flatly 63 through 66. Damages, they deny damages. They deny the injunctions on paragraph 68 and 69. Prayer for relief. So this is what Infowars is asking the court to do. Infowars denies that plaintiff is entitled to any relief, including monetary damages claimed in the Section A of his prayer for relief. B. Infowars denies that plaintiff is entitled to injunctive relief claimed in Section B, and Infowars denies that plaintiff is entitled to any other relief, including costs claimed in Section C. Demand for a jury trial section. Plaintiffs demand that all issues be determined by a jury trial does not state any allegation. Infowars is not required to respond. To the extent any allegations are included in the demand, Infowars denies those allegations. Affirmative defenses. Without admitting or acknowledging that it bears the burden of proof as to any of the following affirmative defenses and based upon information and belief, to date, Infowars asserts the following affirmative defenses and reserves the right to amend its answer as additional information becomes available. Okay, so this is important because if you fail to assert an affirmative defense, you might waive it. It depends on the defense. And you should... This is just a common phrase to reserve the right to amend your answer because something might come up either in discovery or in talks or whatever, or in the other party's answer that gives you more information and allows you to make a definitive statement that you couldn't make beforehand. And so they have reserved the right to amend their answer. So these are affirmative defenses. So an affirmative defense typically states that, well, or typically is okay, so this allegation is true. I did this thing that they're claiming is unlawful, but it is lawful because of this affirmative defense. All right, so that's an affirmative defense. And oftentimes affirmative defenses are statutory. They're in the law. They're written specifically, and there are elements to prove. Affirmative defenses only work if you've done the thing that you've said. So it's important that they have said they're not admitting or acknowledging that it bears any burden of proof here, but these are the affirmative defenses that they're asserting should a court determine that they have done these things. So here we go. First affirmative defense is fair use. And if you remember in the other video, which was months ago, and I barely even remember, fair use is heavily discussed. And they're going to discuss it here and give us just a little mini memo on what fair use is and how it applies to this case. So this section will be, this is their chance to argue to the judge straight out of the gate. All right. So these paragraphs, sorry, I was going to start and then I remembered something. These paragraphs start over at 1. And they do not correspond with a paragraph in the complaint. So these are their new... This is almost... It's not a counter complaint, but it's their narrative is done. This is ours. Here's where it starts. Okay, so fair use. 1. Plaintiff's claims are barred by the doctrine of fair use pursuant to 17 U.S.C. 107. The purpose and character of Pepe's use in the poster is highly transformative, more than satisfying the first non-exclusive fair use factor. The poster's use transforms Pepe's original expression into one with new expression, aesthetic, or meaning. Commentary is upon the history of the United States and its cultural tradition of choosing leaders through elections. This tradition is represented by the United States flag and U.S. Capitol building. The use of Pepe's head is a commentary upon the significant impact of using a meme that contributed to the highly improbable election of Donald Trump. Graphical historical commentary has a long-standing Western tradition, ranging from the Bayeux Tapestry to using thumbnails of Grateful Dead posters to chart the band's cultural history. Memeing is transformative as it comments upon key insights using graphics, an increasingly preferred means of communication as readers move away from text. That's a weirdly structured sentence. Let me take out the... Is this in a positive? I think that's what it's called. Memeing is transformative, an increasingly preferred means of communication as readers... This is just a bad sentence, okay? Too many commas. But they're saying that memeing is increasingly preferred and as readers move away from text. They really didn't need this comma here. They should have put a period here after using graphics and then start a new sentence. It is an increasingly preferred means of communication. Very weird. Very weird. Bad job. Love him or hate him. It's a weird phrase to throw into a lawsuit, but love him or hate him, the transformed Pepe was a historical factor in the election. The poster graphically answers the question, who caused the election of a TV personality with a 12% chance of winning? That's good. This is a good argument. It doesn't fully flesh out the transformation commentary, but we'll see what happens here. The transformative commentary also conjures up, at least in part, parodic elements of the original Pepe. The original Pepe is innocent, carefree, and does whatever feels good man, irrespective of its effect upon others. Using these characteristics as raw materials, the transformed Pepe becomes knowing, cares that the status quo was not good, still supports Trump because it feels good man, and does not care what others think. The right-of-center commentators shown are also unapologetic for their views and advocacy, as was the candidate himself. By including Pepe, the poster comments on the nature of the character and how it compares with the attributes of the individuals on the poster, including Donald Trump. All characters are depicted as they are, not celebratory or smug. This transformative commentary is striking by the subtle and incongruous background placement of Pepe's anthropomorphic frog image juxtaposed with humans in American iconography. While some may find the posing of a frog alongside humans and the retaining of a key attribute of the original Pepe, my support of Trump feels good man, to be amusing, a commentary need not be amusing to qualify as a parody. Pepe's transformative use is an implicit rebuke to postmoderns placing subjective feelings as the highest value in selecting a candidate. This is rhetorical. It's very much not a legal argument, right? They're trying to persuade the judge that Pepe is transformative, or that their image of Pepe is transformative from the original. And to be clear, I fully agree that Pepe is transformed. I'm not sure if they're going to go down the route I went down. Let's see. But I mean, I would be focusing a lot more on the history of the transformation of Pepe, how it was transformed prior to their use of it, and that their use is not derivative of anything by Matt Furie, but rather by a transformed... it is a further transformation of the previous transformation. So let's see what they say, though. Okay. Oh, yeah, here we go. Sorry. Paragraph 4. Plaintiff pleads that Pepe was used in the election by the candidate's family himself. The poster was created after the election and, rather than exploiting Pepe, it included just enough of the character to enable commentary on it. The poster uses only an altered version of Pepe's face, because the character's face most readily conjures up the original. Furthermore, Pepe's face is given a new coloring and shading to add to the new aesthetic, meaning, and message the character is being infused with in the poster. The new coloring and shading is shared with the individuals on the poster as part of an overall theme tying them together. By unifying the individuals through common coloring and shading, the poster furthers the message of commonality between Pepe and the others. Additionally, the materiality of the use to the overall poster is limited, as Pepe is not the primary focus of the poster. Donald Trump is. Pepe does not dominate the poster, is not in the center, and is a very small overall portion. Finally, the amount and substantiality used of the original is less important owing to the widespread use of Pepe elsewhere, as plaintiff repeatedly pleads. And it's always good to throw in a jab that the plaintiff is admitting that his character is used everywhere. when you're talking about suing someone for like using your character. Well, everybody else is using the character also. And what they haven't hammered on yet, and I don't know if they will, is just how much Matt Furie hates everybody's use of Pepe up to this point. Like, no, I shouldn't say everybody's use. He hates what Pepe has become. He hates what it has been transformed into. He flat out lays out the case for transformative use in the complaint. They should be pouncing on that a little harder, in my opinion. But maybe they will. Maybe they will. But this is important. Pepe is not the key point of this poster. Pepe is an ancillary figure in the poster. It would be just like saying Milo Yiannopoulos is the key figure in the poster, when clearly neither of them are. Donald Trump is the primary focus of the poster, and the overall idea that there was a team of people that made this happen, and this is the team, is clearly a theme in the poster. And Pepe is clearly a member of that, certainly as representing Pepe himself and Pepe as memes generally. He has become iconographic. Number 5. The poster does not substitute for plaintiff's alleged works, such as Boys Club comics. The purpose of the character's use is distinct from any of the alleged works put forth by plaintiff, and plaintiff's pleading strongly implies that he would not have licensed Pepe's use to the poster's creator. As moral rights in the United States do not extend to graphic images, plaintiff has not suffered a cognizable harm under copyright law simply because he does not like certain individuals included on the poster or disagrees with the poster's message. As transformative commentary providing new information, new aesthetics, new insights, and understandings with some parodic elements borrowed from the original Pepe character, the poster is the very type of use that the fair use doctrine intends to protect for the enrichment of society. And that's a fairly good argument. Not as fully fleshed out as it could be, but this is an answer. This is not a memorandum, and so they do have to be a little careful on how they argue. They can't just like rail out a bunch of stuff and provide a bunch of evidence and all sorts of stuff. That's what trial is for, or for motion papers. So that stuff will come, I assume. But for now, this is a good summary argument for fair use. So their second affirmative defense: abandonment or forfeiture. And this is going to be, I'm guessing, kind of brutal. Paragraph 6. Before the alleged infringement commenced, plaintiff abandoned or forfeited at least some, if not all, copyrights he may have had in and to Pepe the Frog through one or more overt acts. Now, these are overt acts. Copyrights don't expire because people don't use them. Copyrights have a long duration, something like 70 years, before they become fair public domain. And it's like 70 years from the transfer to the last entity or something like that. But an overt act of abandonment can actually, it's an indication to the world that the copyright is free. For example, creating a YouTube video that says, "I no longer own this, you are all free to use it," would be an overt act of abandonment of the copyright. Okay? I don't think Matt Furie did that, but let's see what they say he did. So forfeited at least some, if not all, copyrights he may have had in and to Pepe the Frog through one or more overt acts, including, without limitation, making public statements and interviews with one or more publications which independently or collectively constitute one or more overt acts indicative of a purpose to surrender his rights in and to Pepe the Frog and to allow the public to copy Pepe the Frog. I think what they're referring to there is an interview in which Matt Furie basically said that people were welcome to take Pepe the Frog and use him before he was used as a political campaign. Well, here we go. For example, in an August 2010 interview with the online publication KnowYourMeme.com, plaintiff was asked, "How about the people that actually crop out Pepe's face and use it? How do you feel about people remixing your work?" And there's a footnote, Q&A with Matt Furie. Oh, it's just a link. Boring. Plaintiff responded, "I really don't mind. I was like, it doesn't look the greatest, but I don't care." It's not an explicit forfeiture. but it does indicate that he is not very concerned with the copyright. Further, in a July 2015 interview with the online publication Vice.com, plaintiff was asked, "You don't feel weird about Pepe the Frog being completely removed from its original context in your comics?" Plaintiff responded, "I don't really see it as being something that's negative. I don't really care." Now, what they're advocating for abandonment here, not forfeiture or surrender, because they're saying, you know, he left it. He's giving indications that he doesn't care. He's not interested in protecting his rights. In yet another published interview, this time in New York Magazine online publication Select/All, plaintiff stated, "I've realized that Pepe is beyond my control. He's like a kid. He grew up and now I have to set him free to live his life. It's all good." Plaintiff went on to state, "I just sit back, relax, and let the Pepes fall where they land." That sort of looks like an abandoning statement. Further, plaintiff acquiesced with full knowledge to the publication of a vast number of copies of the allegedly infringed work without copyright notice. Now, this is more of a trademark claim. Failure to enforce a copyright or waiver of your right to enforce a copyright does not mean that you waive all rights to enforce all future copyrights. So that's not a good, this is not a solid legal argument on its own, but by supporting it with all of these statements by Matt Furie that he doesn't care, that other people are doing it, and he's good with it, that kind of, it's used as persuasive. It's not authoritative, okay? Accordingly, plaintiff's claims are barred on unenforceable based on the doctrine of copyright, abandonment, or forfeiture. Third affirmative defense, innocent infringement. Prior to the filing of the original complaint on March 5th, 2018, Infowars was not aware that its acts constituted alleged infringement of plaintiff's alleged copyright, and Infowars had no reason to believe that its acts constituted alleged infringement of plaintiff's alleged copyright. That's a weak one. Pepe is a created character, and Infowars is certainly familiar with created content, and having a copyright on it, whether or not there's a registered copyright. You create work and it belongs to you. And Alex Jones is a content creator. Infowars is full of content creators. They know. I don't buy that one. Okay. Fourth affirmative defense, unavailability of statutory damages and attorney's fees. Plaintiff is barred by 17 U.S.C. 412 from claiming statutory damages or attorney's fees under the Copyright Act in that any alleged acts of infringement occurred before first registration of the plaintiff's alleged work. So they're saying that no copyrights were registered before Alex Jones or Infowars or whoever created this poster did. So that's interesting. I didn't look at the dates. Oh, excuse me. I got that good yawn going. Let me see here. I don't have the registration. I don't have the dates of the copyright registration. They're not listed on the complaint. The registration numbers are listed on the complaint. And it's very interesting because why don't they list the dates of the registration? And it might be because they waited to apply for registration of those copyrights, which are all numbered about the same. Looks like all of them were registered about the same time. So I'm kind of thinking that maybe the registration of those copyrights occurred after anything they put in the complaint. Oh my goodness. All right. So that's interesting. So this statute must say basically you can't get statutory damages or attorney's fees if you filed not under the statute. Now that's statutory damages and attorney's fees. That does not mean they are barred from the common law damages of copyright. Okay, so that they could still make a common law case for copyright. They're just barred from the statutory claim. Fifth affirmative defense, invalid certificate of registration. Plaintiff's claims are barred to the extent they rely on U.S. copyright registration number VA00020744461, purportedly covering the work entitled Pepe in Blue Shirt. because it does not satisfy the requirements of 17 U.S.C. 411. The certificate of registration contains inaccurate information that was included on the application for copyright registration with the knowledge that it was inaccurate. This inaccuracy, if known, would have caused the Register of Copyrights to refuse registration. Plaintiff's application for copyright registration submitted on or about September 1st, 2017, stated that plaintiff is the author of the work. However, plaintiff admitted during an interview with Vice.com in 2015 that he was not the author of Pepe in Blue Shirt. Here's the quote. But there are two things I don't like about Pepe being removed from its original context in the comics. 2, he's got randomly a blue shirt and brown lips, and that's his accepted outfit now. Those are two things that kind of piss me off about it. Other than that, I don't really care. The creator of Pepe the Frog talks about making comics in the post-meme world. Okay, so he's saying that Pepe's blue shirt and brown lips were added by someone else. Apparently, that's the implication of that quote. So if that's true, he can't register that copyright. Now, that's only one of the copyright registration applications, and so it would only apply to any damages for that particular number. Okay. Plaintiff's admission demonstrates that the application for copyright registration was made with plaintiff's knowledge of the inaccuracy in authorship. That's true. The Register of Copyrights would have refused registration if he had known the inaccuracy in the authorship. Matt Furie's counter argument here is that, right, but Pepe is a derivative work, and I have exclusive rights to all derivative works of Pepe. That's the counter argument, but I'm not a copyright expert, so I don't know how that plays out with the registration of the copyright, but certainly that'll be his argument, is that while I didn't create the Pepe and Blue Shirt, I am the exclusive owner under the copyright statutes of the derivative works, and therefore I can actually copyright it because it's mine. 6th affirmative defense, de minimis use. Plaintiff alleges infringement of plaintiff's copyright interests without qualification in paragraph 65. After pleading in paragraph 62 that the underlying basis of the claim is allegedly copyrighted books, rather than copyright interests exclusively in the character and image of Pepe the Frog, and Infowars' alleged use in comparison to the entire book was de minimis. So what they're saying is the claim in the complaint is that they're copying the books, the Pepe books that they're based on, not the image and character of Pepe himself, but rather the specific works that are copyrighted and owned by Matt Furie. And so therefore, Infowars is saying that their use of just Pepe's head in just one small spot of the poster comes out to a de minimis or a very minimal use and is not infringing based on the context, based on being contrasted with an entire book copyright. So, yeah, that may fly for actually all of the copyrights that are registered, listed in the Second Amended Complaint, are for full books. So that would be their, there you go. So defenses. So these are defenses that are not reliant on having committed the act and then having some sort of specific statutory defense. Without admitting or acknowledging that it bears the burden of proof to any of the following defenses and based upon information and belief to the date, Infowars asserts the following defenses and reserves the right to amend its answer as additional information becomes available. First defense, lack of personal jurisdiction. This court does not have personal jurisdiction over Infowars to enter a judgment against Infowars. Now that's interesting. Second defense's venue is improper in this court. Now, let me take a peek. Oh, this is filed in the Central District of California, Western Division, rather than in Texas, where Infowars is located. So this is kind of weird because Infowars is located in Texas, so the acts allegedly occurred in Texas. A California court would only have, including a California district court, which would be federal, would only have jurisdiction over Infowars if there were sufficient business contacts, just like any other jurisdictional question. So, do they have a significant enough relationship with California for a California court or a federal court in the California district to exert its authority over the entity? Infowars is saying no, they don't do any of the things. Now, Matt Furie's argument is that they have an online store and they sell to people in California and they do all this stuff and they market in California and they have radio shows in California. But for Infowars, they have specifically denied having radio shows, having an online store, selling the poster at all. So if that's the case, Infowars may not have any significant ties with California or the district that this court is in, and therefore they would not have personal jurisdiction. Hard to say. Hard to say because I don't know anything about Infowars. The problem is the things that Matt Furie alleged that Infowars does, Infowars has specifically denied. So he would have to then he'd have to make the argument that they do these things for the court to enter to claim jurisdiction. So second defense is improper venue. Venue is improper in this court. The argument there is basically that all of the information about Infowars LLC is going to be probably in Austin, where they're located. And if you want to have trial with discovery and bring in people and witnesses and stuff like that related to Infowars, the proper venue is going to be in Texas. Jury demand. In accordance with Rule 38 of the Federal Rules of Civil Procedure and this court's local rules, Infowars respectfully demands a jury trial of all issues triable to a jury in this action. So they are asking for a jury trial, not a bench trial. Prayer for relief. Wherefore, defendant Infowars respectfully requests that this court enter an order. A. Dismissing plaintiff's second amended complaint with prejudice, finding that plaintiff shall take no relief from his complaint therein, awarding Infowars costs and attorney's fees herein incurred, and granting Infowars such further and other relief the court deems fair and just. So there's that. Here's certificate of service. Not really interested in reading through that. Won't have any impact. So there you go, guys. Their defenses are predictably fair use, abandonment or forfeiture, innocent infringement, and then the more legal defenses come in later. One thing that I'm sad that they didn't hammer on was the fact that Matt Furie killed Pepe. He did a comic where Pepe died, and he stated that the purpose of that comic was to try and reclaim the historical image of Pepe because it had been so transformed from the original intent. I thought that was just a juicy piece that they really could have hammered home, but they didn't do it. Maybe they do it in the Free Speech Systems LLC answer. So anyway, this is Infowars' answer. You have been through it with me. Hopefully we will see some more movement soon in this case. Keep an eye out for the Free Speech Systems LLC answer. I think it's probably out there. There were 2 filings for answers, but I assumed it was just a duplicate. That's my fault for assuming. Thank you guys for watching this. If you have any questions about it, drop them in the comments. If you want some specific discussion about any of the aspects of this case, be specific about it. Also, as a fun thing, Leonard French has also reviewed this on his the Lawful Masses site. He reviewed the initial complaint. I don't know that he's done anything with these answers, but he, I think, disagrees with me on how this will turn out. So it's interesting to give his video a watch and then troll him politely in the comment section. And by troll him, I don't mean actually troll him. Don't do that. I mean, ask him questions. See if he'd be interested in re-engaging the case now that the answer's out, and he could look at that. If he hasn't, I don't know. I haven't checked. If you happen to see this, Leonard, good work, buddy. Keep it up. I still disagree with you on this case, and I think Alex Jones has a really good claim for fair transformative use. But we'll see. We'll see. Anyways, thanks, guys, for watching. Check out the next video. Of course, check out all the stupid links in the description for all the various social medias that I don't keep up with enough. But if you have specific questions you want to ask, definitely patreon.com/lawsplaining. Follow me, donate money if you feel like it, listen to the audio. There are perks for $5 and up Patreons. And if you want to hear specific content, that's a great way to reach me. Send me a message and we'll talk about it. All right. Thank you so much. And you guys have a good day until the very soon next time. Peace.